Thanks, Senator Carper. Thanks, Mr. Chairman. Ms. Wood, there's a belief by some environmental advocates in the EPA that this Supreme Court stay on the Clean Power Plan doesn't include all the aspects of the so-called Clean Power Plan. The advocates in the EPA seem to believe that the court somehow meant to allow the EPA to continue working on aspects of the rule, despite the court ordering that the rule itself be stayed at the request of the states and the utilities. And then it seems to me that these advocates and the EPA want to debate what the meaning of the word is. As you say in your written testimony, the stay preserves the status quo. New work on aspects of the so-called Clean Power Plan is not preserving the status quo to me. It means except in the minds of this out-of-control EPA. The idea that the Supreme Court would issue a stay in this case really is extraordinary, and the justices wouldn't take such an action if there weren't really serious concerns. David Doninger, a senior Natural Resource Defense Council attorney, which is a liberal group, said in January of this year that if the Supreme Court issued a stay on the Clean Power Plan, he said it would be an extraordinary step. In fact, in Energy and Environmental Daily article in January, he said it's extraordinary to get a stay from the D.C. Circuit. It's extraordinary to get one from the Supreme Court. So we all know the Supreme Court made that extraordinary step, and they did it for a good reason. So could you share with us why you think the Supreme Court took this extraordinary step to block the EPA's Clean Power Plan rule with a stay to preserve the status quo, and how do you believe the Michigan versus EPA case may have played a role in this?
Thank you, Senator. You're correct that this was an extraordinary step. To my knowledge, the Supreme Court has never stepped in before and stayed in an EPA rule before the lower court had ruled on the merits of it. So it was an extraordinary step. I think there were really two primary reasons why the Supreme Court took this step. The first is that there are many legal infirmities with the rule, and those were laid out, for the justices to see. And the other is accompanying the stay applications were 84 declarations from, wide number of sectors, from states, from electric utilities, from coal producers, from business interests, talking about how they were going to suffer irreparable harm if in the absence of a stay. So when you talk about the Michigan versus EPA case and how that may have played in, that was a rule, the Mercury and Air Toxic Standards, MATS rule, where power plants were required to put on very, very costly control equipment. That rule had not been stayed. It eventually worked its way up to the Supreme Court. The Supreme Court struck the rule down, but by that point, almost all of the plants had already spent the money and put the controls on. And indeed, EPA Administrator McCarthy then made the statement that, this really wasn't a loss for EPA.
Yeah, I appreciate your comments.